and welcome to the program. I am Deji. Now, if there's one name that is most discussed in Nigeria in the past 2 weeks, it will be that of Walter Onnoghen, the suspended Chief Justice of Nigeria. Now, when we checked up the name in Google search engine, it produced a whopping 4,840,000 results in just 0.30 seconds. Of course, that would have changed by now. Now, since the Muhammadu Buhari administration began its fight against corruption 3 years ago, no case has generated so much controversy as that of the suspended Chief Justice. The Court of Appeal has now asked the embattled Chief Justice to return to the Code of Conduct Tribunal for his trial after it turned down his appeal, citing a section of the Administration of Criminal Justice Act and adding that it could not give a ruling in vacuum. So a man that has spent 3 decades deciding the fate of people in the witness box now may have to step into the same box for his own fate to be decided. Nigerians are waiting to hear from the National Judicial Council after it issued queries to both the suspended CJN Walter Onnoghen and the acting CJN Ibrahim Mohammed. Both men were given 7 days to respond to the petitions against them. Onnoghen, who was alleged to have grossly violated the provisions of the Code of Conduct Bureau as a public officer by not declaring some of his assets, was said to also operate multiple bank accounts with local and foreign currencies. Nigerian Bar Association, of course, has been sharply, the Nigerian Bar, I should say, actually has been sharply divided over the issue. It is believed that while some senior lawyers are vehemently opposed to the suspension and trial of Onnoghen by the federal government, many junior lawyers feel the man must be allowed to go through the legal process of cleansing and prove himself as an incorruptible judge. There are reports, of course, that some senior lawyers have met with the Vice President Yemi Osinbajo, who, by the way, is also a lawyer, to discuss the issue. The senior lawyers consider the travails of Justice Onnoghen as a dent on the entire judiciary and a situation that must be managed well before the whole world. The Nigerian Bar Association also failed to get maximum support for its call on lawyers to boycott the courts. While some lawyers complied with the directive, others ignored it and went to court on the 2 days the boycott was scheduled. There have also been different rallies in the last 1 week for and against the suspension of the CJN. Some of the rallies, of course, took place at the U.S. Embassy and UN office in Abuja. So Chief Justice Onnoghen is to return to CCT, that's the Code of Conduct Tribunal now, on February the 4th for the continuation of his trial with Hills. Now, the question is, will his lordship survive a test of integrity? Will the acting CJN too be able to defend the petition against him? He is accused of misconduct for accepting to be sworn in as acting CJN. And of course, what are the options before the NJC on this matter? What kind of image is this case attracting to Nigeria before the international community? Joining me now to discuss all these and more is Jiti Ogunye, who is, of course, a constitutional lawyer and the chairman board of governors of the National Board, that's the National Association now of Democratic Lawyers. Mr. Ogunye, thank you very much for joining us on the program. Let me start by asking you, I mean, I saw the statement issued by your group, the National Association of Democratic Lawyers, and you put forward some interesting suggestions there. But something you did say about the NJC, that the NJC did not act with speed on this matter. Could you expatiate more on that?
Well, what appears to be the case, most unfortunately, is that the NJC reluctantly acted in this matter, when indeed it ought to have apprehended the dimension of the matter and the turn of events, and it ought to have acted proactively to be seized of the situation and then deal with the situation in a manner that is consistent with the rule of law and in a manner that ensures that the dignity, the morality, the integrity, the honor of the legal profession and indeed of the judiciary is preserved. The NJC ought to have had its 88th statutory meeting on the 15th of January 2019. Indeed, a day after the date the CJN was supposed to be arraigned before the Code of Conduct Tribunal. And that meeting was unceremoniously postponed on the orders of the chairman of the NJC, who incidentally is the embattled Chief Justice of Nigeria. The meeting was postponed indefinitely. So that meeting that was postponed indefinitely was now hurriedly requisitioned by members of the NJC, and the NJC then held an emergency meeting. An emergency meeting. That was how the meeting was characterized by the resolution that came after the meeting. So from a regular statutory meeting, the NJC moved into a phase of emergency. And the question every reasonable Nigerian will want to ask, including lawyers, is why did the NJC have to wait for that emergency to arise? Why did they have to be stampeded into a meeting? In other words, it does appear that if the president had not stampeded the NJC by that suspension of the CJN, the NJC might not.
Sorry to cut you now. Are you in essence, could we say that, for instance, that, look, the president decided, or the executive arm of government now decided to move in and take the action it took just because the NJC appeared at the initial stage not to want to take control? I mean, especially when the CJN himself postponed the meeting of the NJC indefinitely.
No, that could have been a critical factor. They are a chain of events now. The Code of Conduct Tribunal sat on the 14th. It was a Monday. The CJN was supposed to be in court. His lawyers argued that although he received the processes of the CCT, he received the charges through his personal assistant, and this was declared in court. But all the same, they rode on the hobby horse of technicality by arguing that that was no personal service, and therefore that was no good service. So the matter was then adjourned to 22nd. Of course, 22nd, the arguments continued. The CJN didn't appear before the CCT, and the matter was then adjourned to the 28th. In the meanwhile, the CJN and his lawyers approached the Court of Appeal, and the Court of Appeal, gave an order which was temporary, an order of stay, to enable it write what will appear to be a reasoned ruling on the request for stay, on the application for stay, which it eventually did on the 30th, and ruled that the proceeding before the CCT, being a criminal or a quasi-criminal proceedings, could not be stayed by virtue of Section 306 of the Administration of Criminal Justice Act. So, if you look at all that, there was a temporary stay, the NJC will not meet. So, those factors could have weighed heavily on the mind of the executive, which was restive anyway, just to ensure that something happened. And so, it appeared that that was what made the executive to force the issue by ordering the suspension. And it was in reaction to that suspension that the NJC, whose meeting had been postponed indefinitely, now had to hurriedly call an emergency meeting. That's the point
absolutely. I mean, it's difficult to follow that. Now, help us to make sense of the decision now, the verdict of the Court of Appeal, of course, which asked the CJN to go back to stand his trial at the Code of Conduct Tribunal. Does it basically, could we say, the verdict of the Court of Appeal basically confers jurisdiction on the Code of Conduct Tribunal, that there is nothing wrong? Because the argument before now had always been, look, the NJC should hear the case first before it goes to the court. But it would appear, could we say with the verdict of the Court of Appeal that the Code of Conduct Tribunal actually has jurisdiction to hear this case?
No. That was not the issue that was before the Court of Appeal. The issue before the Court of Appeal was not whether the Code of Conduct Tribunal had jurisdiction to hear the matter at that stage. That issue was yet to be consummatedly raised before the Code of Conduct Tribunal. Nigerians can recall that the preliminary objection that was filed before the Code of Conduct Tribunal was yet to be argued. The preliminary skirmishes that we had at the Code of Conduct Tribunal had to do with the issue of service, the issue of appearance, the issue of the parallel orders that were granted by the Federal High Court and the National Industrial Court, purportedly restraining the CCT from having the CJN arraigned before it. And of course, there was a ruling on that, a 2-to-1 ruling. Two members of the CCT holding that they had the power to go on regardless of those parallel decisions of both the National Industrial Court and the Federal High Court. These were the initial skirmishes. The issue of the preliminary objection, which I believe was predicated on the case of Nganjiwa and the Federal Republic of Nigeria, reported in 2018 for Nigerian Weekly Law Report, part 1609, at page 301, in particular, at page 341 and 349, to the effect that no serving judicial officer against whom a case of misconduct may be alleged, which misconduct may constitute a criminal offense, can be investigated for that criminal allegation or indeed prosecuted without first and foremost being
but I have a question.
Process
I have a question.
Just a minute, by the NJC. So that preliminary objection was yet to be argued. So what the Court of Appeal simply did was to treat the application for stay of proceedings before the lower court. And I guess that application was predicated on the fact that, those parallel courts are granted prayers and all that. But the Court of Appeal didn't go into all that. What the Court of Appeal just ruled was that by virtue of Section 306 of the Administration of Criminal Justice Act, a section that had been interpreted by the Supreme Court in the case of Olisa Metu and the Federal Republic of Nigeria, no criminal proceedings can be stayed again in any court in Nigeria. And that was an intervention that came after a long while. In this country, criminal prosecutions were perpetually stalled by the antics of lawyers who will file a preliminary objection, insist that there is no prima facie case before the court, or in the course of trial, file a no-case submission. Once they are overruled, they bring an application for stay, file a notice of appeal, and then insist on arguing those cases through the entire gamut of the judiciary of the ladder. So that's what we saw in the cases of those governors.
If you can hear me, sorry to interject, if you can hear me. Unfortunately, we haven't got much time. So something I want to ask you, because it came through in your letter, the press statement you put out, and you just said something, you alluded to it in your in the course of speaking on this issue now. And this is a direct question I'm asking you, are you still arguing that the NJC should hear this case first before it goes to court on the basis of the case between Nganjiwa and versus the federal government? Because the argument of some people is that, look, the case against Onnoghen, the reason why he was taken before the Code of Conduct Tribunal is because he is first and foremost a public officer, and that he actually signed that asset declaration form on the basis of being a public officer. It's the same form that every other public officer signed. And that's the reason the Code of Conduct Bureau issued that query to him. So why then should we say that he cannot be tried before the Code of Conduct Tribunal, and that the NJC has to hear the case first before trial?
I understand your question. Let me be clear. That's not my invention. That's not my preference. That's not what I wish to see happen. When the Nganjuwa's case was decided, my argument, and I said this in your studio, was that no judicial officer enjoys immunity in the Constitution. So you can't even say that they shouldn't be investigated for criminal offenses or charged to court or prosecuted for criminal offenses. But that's what the decision in Nganjuwa says. And that decision is binding on all authorities and processes in Nigeria.
But then,
those who are making these arguments...
I understand you. Sorry, I understand you. But the point is this. What I'm saying is that the argument is that the CJN is not being tried at the Code of Conduct Tribunal because he's the CJN of the country. He's been tried because he's a public officer and actually filled a form.
That argument is air splitting. That argument is air splitting. The Nganjuwa case does not give any room for such exceptions. And you can be creative about a legal challenge. If you are confronted with a legal challenge, you then start looking at ways and means where and how you can dodge that legal obstacle. I think that's what is being done, with that kind of argument. You can make the point that, yes, the CGN is not being tried as a judicial officer, for misconduct. It is because of alleged breach of code of misconduct. But the area of the law that I've just cited is total. The intention of that decision was to insulate judicial officers and prevent them from being tried as the CJA or any other judicial officer is being tried. Indeed, the decision went ahead to say that it was desirable to have a judge stripped of his judgeship first before he could be arraigned before any court of law in Nigeria. So that's not my judgment. I disagree with it, but we are all bound by it. And that's why, as a lawyer who is disciplined, who knows what the principle of stare decisis and precedents, are, that's why we make such argument. Not because it is our preferred argument, but it is simply because that's what the law today has said. And that's why that decision is being appealed against. For those who are arguing to the contrary, I think that they just understand that something must give. There must be a deus ex machina. If you don't do it that way, you don't force the hands of the NJC that way, the NJC is a body that is almost loyal and have allegiance to the CGN, who nominates and appoints 12 of its 22 members, a majority of them who will be beholden unto him. So a lot of people just think that, yeah, the law can say one thing, but we've got to force it. And that's not the way I argue. You may disagree with the law, but you have a duty to faithfully state what the law has said, even while expressing your disagreement. And that's what we have done. That we're not simply saying that that's what is best in the circumstance.
Finally, just before we go, how damaging do you think this is to the Nigerian judiciary and even the Nigerian state as well?
It is damaging, but the damage can be remedied. To start with, one has to understand that the damage is more pronounced because we are talking about the apex, the very zenith, the acme, the apogee, indeed, of the judiciary in Nigeria. And so people can make a lot of assumptions that that is representative of what is going on in the Nigerian judiciary. But the good news is that it is not. Corruption in the Nigerian judiciary is not pervasive. those who engage in it with the lawyers, many of them senior lawyers, who act as conveyor belts, are very powerful in the legal profession. But I must tell Nigerians that they are not the totality of the legal profession. They are not the totality of the judiciary. A lot of judges, many judges, are of impeccable integrity. And those ones agonize now because of incidents like this. It's very damaging. And that's why we call on the CGN to shun the grandstanding that his lawyers is putting up. He should refuse to be led to the Golgotha. Throw in the towel, resign, and then do what is right by the Nigerian people.
All right, Mr. Ogunye, thank you very much for joining us on the program, and thank you very much for your time.
Yes, it's my pleasure.
All right, we'll take a short break, and when we come back, we'll be talking about the Transparency International's latest report. That's its report now on the Corruption Perception Index. How has Nigeria fared in that latest report? That's what we'll be talking about. Stay with us. On Deji 360, we don't just ask the questions. What is wrong with amending the Constitution the way the National Assembly members have been doing it? We seek answers.
Constitution is constituent. Our problem is not lack of laws. Our problem is lack of the willpower to implement our laws.
Answers that provide clarity.
While we negotiate, we should try to make it a point that the girls must be complete.
The clarity you need to make informed judgment so that you can make the right decision and take action. People are saying it is you politicians that are responsible for this, that you are the reason why this is happening.
All these dollars that call themselves governors in this country. I wish we had people like Tony at the National Assembly. God forbid that I go to join that band.
Deji 360, providing clarity to issues.